Okay, we're going to go ahead and get started. Thanks very much. Welcome to you all. A lot of basic housekeeping things first, and then we will dive into the substance. So first of all, again, we have a few people coming in at the end. Please make sure you sign the sign-in sheet so that you're eligible for the extra prize at the end. Please put your name, first and last name, on your red ticket. We'll pass this around again. With the hotel night, you get one hotel night if you win, up to how much? $300. Up to $300. And look around the room. In February, your chances of getting a hotel room are really good because we do one hotel room each class, and when we do the barbecue, which will be whatever the date is, we're going to do a barbecue for you following Judge Shepard's Florida.
January 23rd.
January 23rd. So put that down. We do actually Peter Kelly does the barbecue, and we do 2 hotel nights. 2 different people. You win just once. Sorry. And you have to be sitting for the bar this time. I think everybody here is. Sometimes we get people who come in and sit in the class early. Then you have to wait till you're actually taking the exam. I will do the drawing roughly halfway through. We'll see how it goes. This session will be a relatively short session. Most of the sessions will last for a good 3 hours. Some of them might go a little bit longer than that. This one, probably 2 hours at the most. Let me tell you a little bit about what we're going to be doing in the next couple of months for these classes, and then ask for any questions you have before we dive into substance. So we're going to be meeting approximately once a week. We're going to meet twice a week this week because originally we were going to start Friday, but school was closed. So we've got today and then next Friday. Most of the classes are on a Friday, quite frankly, because it's when we can get rooms. And also, we have it scheduled at 3 o'clock, so if you are sitting in lectures rather than doing the lectures online, you can still get here for the classes. We are also recording all of the classes. If you want to watch one again, or if you miss one, you can pick it up. I have a Lexis Bar web course. So you'll find that web course after the video is processed. It gets posted fairly quickly through my YouTube channel, and it's not generally available through YouTube because I want to restrict it to you guys. But if you go in and register for the course, you can then pick up all of the videos. All of the materials will also be posted, and then from time to time some additional things will show up as well. So you can see the schedule. On Friday, you might want to mark Friday down. It's one of the more popular sessions because that's when I will talk about my predictions for the Florida portion of the exam. Today's session is going to focus on MBE. It's the only one that is solely MBE. The rest of them will be a combination of MBE and essay. I tend to focus in my classes on essay because the commercial courses don't do what I do in our essay sessions, and I'm trying also not to duplicate what you're getting in your commercial sessions. But you also see that we have some very important lectures, guest lecturers. Professor Martin's going to be talking to you about commercial law. If you did not take commercial law, or even if you did, make sure you come to that session. They have now tested secured transactions and negotiable instruments, but I can guarantee you they'll continue to go back to the well, so you want to be prepared for that. Florida Con Law. If you didn't take Florida Con Law, please come to Judge Shepard's session. It's a heavy-duty session. He knows his stuff. He goes into it in great detail, but I can promise you that he will prepare you very well for Florida Con Law. And even if you did take it, it's a great review. Professor Kang, many of you probably had Professor Kang for Con Law. If you didn't, still come, because he does an amazing session just on the religion clauses. That one will be coming up fairly shortly. And then we are and we have a business entities one, and we are adding CivPro, the second half of CivPro. Many of you probably attended the first half. Professor Nathanson will come in and finish up CivPro for us. So that's our schedule. Again, would really encourage you to come. I can tell you, because I keep the statistics, I review the statistics, I do reports for the dean, and consistently, the people who come to these classes pass the bar exam. Now, I'd like to say that I have the magic potion, I've got the answer. I'm not so sure it's me, so much as it is the people who come and take the time and sit and do the exercises, write essays for me, really engage in the process. Those are the people who pass the bar exam. So I really encourage you to keep coming, because I think you will get value from the classes that you won't get anyplace else, and also keeps you engaged in the process, which is much more important than you might think. So one final thing for me, and then I'll take some questions before we do substance today, and that is in terms of essays. It's a little bit early, although some of you are probably starting to write essays, and we will on Friday begin our essay sessions. Send me essays for review. Once again, the people who send me essays for review are the people who pass the bar exam. And you can send me as many essays as you like. Some of you may remember Marta Perez, who passed last year, sent me 17 essays. If you know Marta, you would know that Marta would send 17 essays. I read every single one of them, critiqued every single one of them. And it makes a difference again. And the critique that I give you will be different from what you get from your commercial courses. I encourage you, of course, to submit to your commercial courses as well. Just a couple of words of caution on essays that you send me. Number one, it helps to have studied the subject first before you write the essay. So, yeah, I know. But you'd be surprised at how many people try to write essays without having studied the subject. Kind of a waste of your time, then ends up being a waste of my time too. So study it first, then send me the essay. That's number one. Number two, send me something electronically. If you are, if you're typing, obviously, then you send me your typed copy. If you are handwriting, either scan it and send it to me, or take it upstairs and they'll scan it. The reason I want it electronic is, those of you who have had me in class, and many of you have, you know that when I grade exams or practice exams, I type on them all the comments. You don't want me to handwrite my comments. You won't be able to read them. That's why I type. So send it to me electronically so I can send you something that you can use. Now, a couple of housekeeping things. Number one, we will be subsidizing for you the purchase of released questions from the National Conference of Bar Examiners. You will do that through Sarah. I highly encourage you to purchase these questions. They are relatively new released questions, and they keep releasing questions as they go along. If you ask the Florida Board of Bar Examiners, if you ask the National Conference of Bar Examiners, what questions should I practice, they'll tell you the released questions for obvious reasons. These are questions that have actually been used on a recent bar exam. They are real bar questions. And the questions that you're going to get in the commercial courses, they're good. I'm not suggesting that they aren't, but they aren't written by the people who really write the questions. So make sure that you do purchase those questions. Again, you'll do that through Sarah. Other than that, let me ask you if you have out there any kinds of general or specific questions, anything that's kind of eating at you at this point that you want to ask before we jump into today's materials.
What were the name of those questions again?
They're the National Conference of Bar Examiners, NCBE. You go to ncbex.org, and what page is it on? If you look in your packet, it's on the last page. And Sarah has spelled that out for you very nicely, talks you through the process, and again, highly recommended. Yes, sir.
Those questions come with answers, I'm assuming?
Yeah, not analytical answers, but yeah, unfortunately, they don't provide analytical answers. But I'll tell you, if you work questions, even if they're questions that have analytical answers from the commercial courses, and if you look at the question and say, I don't understand, or I'm not sure, or whatever, then once again, use me as a resource. Make sure that you ask rather than just assume. Because sometimes there could be more than one answer that's a good answer, and sometimes, especially with some of the questions from commercial courses, you might have a good reason for disagreeing with them. Other question, and by the way, also in terms of a resource, you've got a lot of resources that are available to you here at St. Thomas. First of all, any question that you ask me, whether it's substantive or study or just I'm freaking out or whatever, I'll always respond. And you can come by my office if you're studying here. A lot of you probably aren't, so you can send me an email message. I respond pretty quickly. As long as I get the message, I respond pretty quickly to it, whatever it is. And if it's a question about a question, or if it's a question about substance, I will answer it. If I don't know the answer, I'll find somebody who does. So that's number one. Number two, of course, you've got, I'm sure, professors that you've established relationships with. You can always call on them. And in addition, we've already notified you of the mentors that we've assigned. So take advantage of your mentors as well. Other questions? All right. So let me ask you as we, and it's, don't fall asleep there in the back. I think the lights are out because when we get the sunlight coming through in the afternoon, you can't really see the screen. So all of you have started your commercial courses, right? It's true, okay? And how many of you, before you started the substantive part of the course, did the equivalent of the pre-course where you do, 5 or 6 days of questions? Most of you have done that or not? It's called different things in different classes. Well, that's ALS is, yeah. Honestly, yeah. Okay, yeah. Now, and the reason I ask is this: the beginning part. We've got a little bit of software there that doesn't belong there. I don't know why that did that. The beginning part of this lecture, it depends on what people have done and what they've encountered. I'm guessing that most of you probably know most of the basic stuff that I'm going to talk about. You know what the questions look like, what the question form is? Yes, no? Would we like to spend a moment on it or not? We're good? We're good. Most of you probably are. And in fact, we may, work through these questions fairly quickly today because I do see a lot of people who have taken ALS. And the sooner we get through, the sooner you can go home. So I'm going to skip past this. And what we're going to do now is we're going to do the question set that's in here. Yeah, get your clickers out. If you don't have one, we got clickers in the front. And I have 2 questions from each of the subjects. And the reason that that I like to do this little set, obviously I can't, I can't cover all of the material in all of the subjects in a couple of hours. So it's not intended to do that, and it's not necessarily intended to identify the tricks, because most of you have already learned all about the tricks too. What we're going to do, though, is as we get to a subject, I want to talk a little bit about how you conceptualize the subject, how you think about it, how you attack the subject, and then, of course, we'll see as we do the questions that some of them, have those pitfalls, the things that you always get trapped by. So with that in mind, let's go forward to the questions. Now, a word of caution on questions as well. People always ask me, what are, which questions should I do? What are the best questions? Well, the best questions, as I said before, honestly, are the released questions. Beyond that, mix it up. Do the questions that you have from your course. If you want to do some questions from a different source, you all know by now we've got a pretty good library upstairs in my office. Mix it up, because the more different kinds of questions you do, the better prepared you'll be. If you talk to people who took the bar exam in July, it was hard, the MBE portion. It was very hard. And people said, wow, those questions didn't look like anything I'd seen before. Correct. as far as I know. I mean, I didn't sit for that exam, so I wasn't in the room. But from everything that I understand, yeah, those questions were hard and they were different. And that's what the examiners do. They know the patterns, they know what they've done in the past, they know how the commercial courses write the questions, and so they try to write in different ways. So, besides the fact that you want to mix it up and do as many different questions as possible, make sure that you don't rely on the questions as your way of walking into the bar exam. What do I mean by that? Do you want to do questions? Of course. But do you want to do all your learning through the questions? No. Do your learning through the outlines. It's boring, it takes a lot of time, but it's essential. Why is it essential? We'll start, number one, with breadth of knowledge. The questions that you get in your commercial courses tend to group in certain areas, the highly tested areas. But the examiners don't necessarily test just the highly tested areas. They're going to go for those little pockets that they know you aren't learning from doing just questions. So breadth of knowledge, number one. And number two, to me the most important thing, is we go through the next couple of months. You're going to ask me a question about a topic, and I scroll through in my brain, and chances are good it's in here, and usually I can find it. I don't necessarily know more than you guys know. In fact, some of you are going to walk into that exam knowing a lot more than I know. But I know how to find it in my brain. And how is that? Because I have my brain really organized, like a computer database. I put it in the right place, and so I know where to find it when I need it. And how did I get there? Outlines. I learn the material through the outlines. It's very organized. I can pull it out when I need it, and I put it back where it belongs, kind of like a nice, neat closet. So the outlines are really essential for that. You will learn information from doing questions, but then it just goes in helter-skelter like a really messy closet. And when it comes time to find the rule, you don't know where to look, and even worse, the question becomes the trigger for the rule. And if you don't see the same question, you don't remember the rule. So do yourselves a huge favor and take the time to do the outlines, no matter what anybody else tells you. It's very important. Now, after you do the outlines, then you do questions. But don't just do questions. Every time after the results are released, somebody will come to me and say, but I did 5,000 questions and I still failed. Yeah, exactly, because you didn't learn the material the right way. So now with that in mind, and understanding that you're just starting your courses now, you may not know much about some of the topics that we're doing here. Some of you may know more than others, especially if you did ALS, or for those of you who have good recall from your first year of law school. But one of the things that you want to do as you begin is to be aware of your strengths and your weaknesses, places where you might need a little bit of extra work and some where, not that you ignore it, but that you don't need to spend as much time. So let's go ahead, and we're going to, obviously because we're using the clickers, we're going to go question by question. Oops, minor detail. I forgot to put the software up. Okay, go ahead and do question number one. Let me get the software up, and then you can just click in. And for your reading purposes, would you rather have the lights on or off? Sure. You're good? Some of you may want a nap anyway.
Yeah.
Just happy to see a real live person.
Yeah, yeah, I know.
And you're not talking at 1.5 either, so that's...
Yeah. It's the downside of the February exam. You don't have any, but honestly, live lectures when they're live, it's just talking
Yeah,
head.
no. It's three-dimensional.
We have a few more in here. Anybody else?
You don't know what this?
Okay, close enough. And as Chris said, you know, you've got lectures now, so you don't have anybody you can talk to. It's another reason to come to these classes. Ask me questions. There's no stupid question. Well, sometimes there are, but I'll try to answer even if it is a stupid question. Most of the questions I get are really good questions, and it gives you a chance to ask those questions you can't ask otherwise. Don't walk around saying, "Well, must be they told me in my class." Ask the questions, get some response. All right, let's see how we did on this first question, which we should have done pretty well on. Yes, we did. Now, let's talk about what's going on here. It's torts. And it doesn't matter who you had for torts. Torts is all about elements. Elements, 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 elements. You know, you probably heard that more than you ever wanted to hear in your first year of law school. It's so important when you get to the bar exam to think about torts in terms of elements. What's my cause of action? And this question makes us focus. It's a simple question, really, but it makes us focus on cause of action, and some people got tripped up. Think about whether it's an intentional tort or negligence or some kind of warranty for products liability. Identify the cause of action, and then think about the elements in order. Because if you think about negligence, for example, which is the subject of this question, if there's no duty, who cares about breach or damages or whatever? So think of the elements in order. Now, we look at this particular question, and it's a simple fact pattern. It's a real case, a case that was noted in Prosser. Got a kid who loses touch with reality after listening to a rock band, commits suicide, and the mother wants to sue. Key here, of course, is the call of the question. The cause of action is negligence. And you need to mark your packet up. Those of you who had ALS, you already know all this stuff. If you didn't, make sure that you have a really messy packet. They don't care how messy it is. The messier, the better. You got to circle, underline, stars, asterisks by negligence. Because some of you, a couple of you, picked C. What's wrong with C? Intent. There's no intent in negligence. It's like there's no crying in baseball. No intent in negligence. So for negligence, and you'll know these elements forever. A lot of this stuff you won't ever remember. But negligence you do. Elements, duty, breach, causation, damages. No intent. A favorite testing trick in the area of negligence, or torts in general, is to give you one tort in the call of the question, negligence, and then a different tort in the answer choice. So you've got to make sure that you match them up. That's simple reading comprehension, but you'd be surprised at how often reading comprehension is the answer. And if we look at the other choices, what's missing from A, by the way? It's true. He died after listening to the music. It's a true statement of fact. But no. Well, there might not be a duty, but there's certainly not what? Causation. Good. Each choice, don't just kind of look at it and say, yeah, it looks good, looks bad. It looks good because you need to take the time to make a little note. Yes, this one's wrong because there's no causation. What's wrong with B?
It's the wrong cause of action to the...
Okay, wrong damages for the call of the question. It's not that you can't have emotional distress possibly in a negligence cause, but that's not part of the elements of negligence. C, we already said, is wrong because it's got intent, which is not relevant to negligence. And then D, because as the case held, There was no causation. Now, make a little note. If you can remember cases as you're going through the materials, particularly when you get to con law and to criminal procedure, constitutional criminal procedure for purposes of the MBE, those questions are based on cases. And in fact, most of the questions that you're going to be doing in your practice and when you get to the exam are going to be based on real cases. Why? Because the holding is the right answer. It's when you draft a question, if you want to make sure you've got the right answer, use a holding in a case. So make sure that you remember that, and especially again when you get to con law and those cases that you learned in your con law class, use that and use the case illustrations that you have in the material. Okay, any questions? Again, this one's pretty simple. All right, number 2. Yeah, please, yeah. You're eating for 2, you can take more. Anybody else on this one? Okay, so notice something first of all. I gave you about 2.5 minutes. Actually, you guys did that one fairly quickly for a long contracts question. Again, some of you have heard this from me before, but if you haven't, don't get too hung up on the speed on any one given question. Now, it is a timed exam. You've got 3 hours for 100 questions in the morning, 3 hours for 100 questions in the afternoon. But as you'll see as we go through these questions, particularly when you get to certain topics like evidence, and I'm guessing CivPro will be the same, the questions are very short. You know it or you don't. 15 seconds and you're done. Take a little bit more time with a longer question. Property contracts, those tend to be your longer questions. Why should you take the time instead of skipping them? Because the examiners know that people like to skip the long questions. And oftentimes, even though it's a long question, it's actually an easy question if you take the time to read it. So that's number 1. And number 2, don't speed through the question. Don't take a question like this one and try to get it done in 1.8 minutes. It won't work, or you'll get the wrong answer. And when you push past your maximum speed, which you'll figure out as you go along, you're going to see your accuracy rate drop very quickly. So pacing is important. Give yourself room on longer questions, and you'll get them right. Other people will get them wrong. And your goal is to get a question like this one right when the person sitting next to you gets it wrong, because that's how you pass the exam. So let's see how we did on, yes, sir.
On the question for reading comprehension, you have on the bottom of it, manufacturers who process it for breach. And on mine, you have processors who manufacture for breach.
Oh, okay. Let me look at, that could just be a typo here.
Okay.
And in fact, it probably is. Yeah, so I apologize for that. Sometimes I revise these questions and I don't catch things like that, which I should. So thank you, Chris, I'll fix that. All right, so let's see how we did on this question. Interesting. Anybody want to tell me what they think the right answer is? Because you're all over the board.
The colors don't help.
The colors don't, yeah, colors don't know. I'm going to tell you in a moment.
I think it's D. No,
B.
C, rather.
B.
B.
Okay, so let's talk about why B is the right answer. First of all, it's a contracts question, right? Okay, contracts. What's the very first question you have?
Contract.
No.
Oh.
What's my governing law? Always, 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 whether it's multiple choice or essay. When we get to Friday, I don't want to have anybody not answer that question right when I ask it on Friday. First question that you address always is governing law, because you got two sets of rules and you have to know which one you're going to apply. This particular question is about, fill in the blank. Well, it is, but I mean, what's the governing law? Because, don't just say it's goods, it is, but no, no, no. Oh, my, no. Merchant status will become important in this question, but never start with merchants. You'll never hear me start with merchants for a good reason, because it doesn't matter in terms of your governing law. Article 2 applies to sale of goods. Goods are
Things that are movable.
all things movable, right? And the subject matter here is
Jars.
jars. Are jars movable? You bet. Article 2 applies. Now guess what? I just wrote you your first paragraph if this had been an essay question. Go through the steps. And even in the multiple choice, you go through the steps. It should be fairly easy here. And by the way, if you have an essay that deals with land or services or something that is not goods, don't say this contract is not about goods, so Article 2 doesn't apply. Don't say the negative, say the positive. This contract is about services, therefore the common law applies, right? This particular contract clearly is about goods because it's about jars and they're movable. So now we know that Article 2 applies. And we know, if we go back up in the facts, that we have a classic 2207 situation, right? So let's go back for a second. Okay, so processor places an order, and the purchase order says quantity. Why is that important, by the way? Article 2. What's the one essential term under Article 2? Quantity. You're making those notes as you read the question. If you're not, you're missing part of the process, right? Make those notes, because you don't know yet whether it's important. Now, just as an aside, before we go further into the question, and again, those of you from ALS, you've heard this stuff before, where do you start in the question? You're going to notice I start with the facts. I don't go to the call of the question first. A lot of people will tell you to go to the call of the question first. Both methods are legitimate. You use the one that works for you. Pros and cons. Why do I start with the facts? Because I'm a really fast reader. I don't like to read every single word. And that's what speed readers do. You just kind of glance at it and get the gist. Killer, deadly when it comes to multiple choice, because every word is going to matter. You're going to have a very short fact pattern, 500 words or less. Every word counts. So you can't skip over words. And if I read the call of the question first, it does focus you in, but it causes you to screen the facts. And for me, that's deadly, because then I'm going to start to leave out facts that might otherwise be important. So I start with the facts first. and I try to predict the call of the question. And if I get down to the call and I have predicted it correctly, then I know I'm going to get the question right because I know what's going on. Now, however, many people do read the call of the question first. It does focus you in. It helps you to sift through the facts. It can be very helpful to you, particularly if you're not as confident in the subject matter. Just a word of caution, though, if you read the call of the question first and then go back to the facts, you have to read the call of the question again. It takes you just a little bit longer to do the question. So factor all of those things into account. Make sure that you try out both methods and find the one that works for you. Whichever one works for you, that's the way you go. So we've got here an order, 100 cases, quantity is stated, size of the jars, that's fine, price, delivery terms, all lovely, but not necessary under Article 2. But notice it says no other terms were included in the purchase order. That should have been a clue right away. If you didn't think about 2207 yet, that should have been a clue, because of course then we get an acknowledgement form, and the acknowledgement form has the following paragraph. No claim or cause of action may be brought more than 1 year after the date on which the cause of action arises. So now we have a fill in the blank. Additional term, or possibly even a different term. The case that I took this fact pattern from actually labeled this as a different term, claiming that the original order reserved all Article 2 remedies. And of course, under Article 2, the default statute of limitations is 4 years, right? So either we have an additional term or we have a different term. We're going to end up in the same place. Now, under Article 2, and of course, processor doesn't respond. Maybe, maybe not. All right, so now we go through the steps of Article of 2207. First step is under 2207 subpart 1, was an agreement formed? Do you have an agreement?
Yeah.
Yes. We got the quantity, we got the price, we've got a lot of terms that they agree on. So a contract was formed. The next question comes then, what do you do with the additional or different terms? So let's do additional first, and then we'll do different. Now, very good. Now we ask, are they merchants? We don't care if they're merchants in terms of formation of the agreement. It's irrelevant. When it comes to the additional terms, as between merchants, we have special rules. If they're not merchants, that additional term would be what?
Knocked out.
No, it's just an offer. If they're not merchants, and it's just an offer that can be accepted or rejected. If they are merchants, and both have to be merchants here. Some of the provisions in Article 2 that are specifically for merchants require just the seller to be merchant or one party to be merchants. They have to both be merchants here. Are they?
Yes.
Sure, because they,
Sell jars.
yeah, they deal in goods of the kind, right? They're goods merchants. They're probably practices merchants too. They're merchants. Now, as between merchants, the additional term, if we're treating it as an additional term, becomes part of the agreement unless, what are the three unlesses? If the offeror expressly limits acceptance to his terms, which the offeror didn't do here, that's number one. Number two, if it's a material alteration. And number three, if the offeror objects within a reasonable time. Very good. It's not 10 days. That 10-day rule does not apply to 2207. Look at the level of detail you have to know. 10-day rule, by the way, applies to what? Not 2207, but not 2206. That's a pretty generic term under Article 2. 2201, the merchant's exception to the statute of frauds. Then you have to respond within 10 days. And that's the kind of thing that they're going to test, whether it's 10 days. And in fact, look at C. C says, because processor didn't object within 10 days, nah, there's no 10-day rule. under 2207. So the offeror did not limit acceptance to his terms. We don't have an issue of an objection. And so the question is, did this additional term, if we call it an additional term, did it materially alter the agreement? And the answer is you bet. What should you look for in terms of material alteration? And this is case law. The comments to 2207 used to list a bunch of cases. They don't anymore. But the cases tended to fall into a couple of groups. And as you do questions, you should look for those groups, again, because the questions are going to be case law based.
Warranty?
Warranties. Disclaimer of warranties, certainly number one. Number two,
Disclaimer of statute of limitations?
it's changes in the statute of limitations, which is exactly what we have in this case. And number three is arbitration clauses unless the arbitration clause is a custom of the industry. Look for those three groupings. I'll repeat them. First is disclaimer of warranties, very definitely. That's considered to be a material alteration. Second is what we have in this question, which is a change in the statute of limitations. When I say a change from the Article 4 default. And the third is an arbitration clause unless it's the custom of the industry. So if we treat the language in the second form here as an additional term, it is a material alteration, and so it is not part of the agreement. And if that additional term is not part of the agreement, what is the statute of limitations? 4 years, because you go to the gap fillers, right? And the gap filler is 4 years, which means they're still timely if brought within, if they bring the cause within 4 years. Now, what if we follow that line of cases that says that that it's actually a different term because the original impliedly reserves the 4-year statute of limitations? Then we've got different terms, right? 4 and 1. What do we do if we have different terms? What do they do? Knockout. There are 3 different approaches, but for the purposes of the exam, you will use the knockout rule. They knock each other out, and you resort to, guess what? The gap fillers again, 4 years, which means B is the right answer, whichever way you approach this question. Now, just a word of caution also. The steps we just took, they love to test 2207 on the Florida portion of the exam. Interestingly, it was a component of one of the 2 contracts questions that they had this last time. So, yeah, will you see it again? Maybe not, but then again, they seem to like contracts a lot lately. So follow the steps, whether you're doing multiple choice or essay. And I promise you, even if you don't see 2207 on the essays in Florida, you will have maybe even a couple 2207 questions on the MBE. Don't give them those points. Make sure you can handle 2207 because you will see it. Questions? All right, number 3. Did you not, really? Did you not? Is yours blank? Yeah. Sorry. Okay, anybody else on this question? All right. Pretty good this time. And it means you weren't asleep, which is very good. I know it's, Friday, no, Monday afternoon. I know, I don't even know what day it is anymore. The holiday does that to you, I'm not back into the routine yet. It's Monday afternoon, but nevertheless. So we have a con law question. And con law on the exam, like con law when you took it in school, we got the rights and we got the powers. And so you want to, con law 1, powers, con law 2, rights. You want to think about it that way. This particular question is a question that deals, of course, with powers. It's the one place on the exam where numbers matter. Article 4, the 14th Amendment, whatever it is, you actually have to know numbers here. No place else, you don't have to know numbers when it comes to Article 2. You don't have to know numbers when it comes to the evidence code, but you do need to know numbers here. They will test you that way, knowing the difference, for example, between Article 4 and, for example, the 14th Amendment privileges or immunities clause. So those kinds of differences matter a lot. Here we've got somebody who is, guess what, a commercial fisher, right? But not just a commercial fisher. Fisher is a what? Corporation. Good. Reading comprehension, because it's actually a pretty easy question. You'll remember, it's this particular question, I kind of combined a couple of cases, but you'll see the cases jumping out. And we know that for the purposes of the Privileges and Immunities Clause of Article 4, that a corporation is not a citizen. Makes life really easy. What about that market participant exception, by the way? Is it an exception? It's an exception, of course, to the Commerce Clause. Is it an exception to? No, it's not. And what you have to be really careful with on these questions is they'll give you a correct rule. And it's absolutely correct. Market participant is not relevant to privileges and immunities under Article 4, but it's not the right answer here because it says yes. Fisher doesn't win because Fisher is a corporation. Now, I want to make a comment about C. I have retained that answer choice. I've changed this particular question, but I always find a way just retain that answer choice for a reason. Years ago, we taught, and when I say we, not just people for the bar, but also your con law professors as well, that you never use the 14th Amendment privileges or immunities clause. Why? Because the U.S. Supreme Court had never used it over a period of 100 years or so. And then all of a sudden, it's been, I don't know, 7 or 8 years ago now, the Sands case, however long ago that was, all of a sudden, the Supreme Court said, we like that clause. And so you have to be careful about these kind of knee-jerk answers. Don't pick this one, which once upon a time was the right answer. It isn't anymore. The Supreme Court changes its mind. It's the Supreme Court. Same thing with Commerce Clause, though, which is why I kind of want to tie that in here. Years ago, when in doubt, pick the Commerce Clause. Because the Supreme Court used the Commerce Clause for just about everything. The Voting Rights Act was sustained under the Commerce Clause. The Supreme Court doesn't use the Commerce Clause quite as much anymore. So while it's still, kind of a nice default if you don't know better, be careful. Don't always assume that Commerce Clause is the right answer. One final comment about the difference between Article 4, privileges and immunities, and the 14th Amendment privileges or immunities clause. Again, those numbers matter. Article 4, state can't deny to citizens of another state the privileges and immunities that it affords to its own citizens. And those privileges and immunities, they can be fundamental rights, but they don't have to be, right? Because if you think about, for example, the Virginia lawyer case, the right to practice law, to engage in a profession, is not a fundamental right, but yet it's protected under privileges and immunities. 14th Amendment says that a state may not deny to its own citizens the privileges or immunities of national citizenship. Well, what are those? Protection of the U.S. Marshal, whatever that means. I've never seen it tested, but it is one of those privileges or immunities. Right to travel is what you want to look for there. And there are certain hot buttons with the Supreme Court, and that's one of them, right to travel. Anytime you see a residency requirement, welfare benefits, for example, it's not a fundamental right, but it might involve the right to travel if you have a residency requirement. And so all of a sudden, we jump up to highest level of scrutiny. So make sure, again, you know your numbers in this one area and that you pay attention once again to cases and case law. Because in the area of con law, some of your professors may have given you, even in the context of multiple choice, questions that push the envelope to see, you know, how you would analyze. When it comes to multiple choice for the purposes of the bar exam, the only way that they can test anything constitutional, which again is con law or constitutional criminal procedure, is by using a real case and a real holding, because the Supreme Court does what the Supreme Court will. Okay, questions? All right, number 4. All right, let's see how we did here. Kind of all over the board. One of those answers, and nobody picked C, and that's good because C is not the right answer. One of the remaining 3 is correct, but look, you're fairly evenly divided. Interesting. The correct answer is D. Now, let's consider why D is the right answer here. First thing you want to do, now there are a couple things going on in this question that you want to pay attention to. The first thing is the statute. If the question gives you a statute, which it may do in property, it also may do in criminal law, use the statute, apply the statute. Now, I gave you a huge gift in this particular statute. I didn't even need to do it. Let's go back to the statute for a second. Anybody want to tell me what the gift was that I gave you in the statute? Yeah, what does it say? okay? I give you all of the tools that you need in the statute, right? So you read it and you apply it. But what do we know about disabilities when it comes to tolling? The disability has to be in existence when? At the moment that the adverse possessor enters. Whether the statute says so or not, the disability must always be in existence when the adverse possessor enters. If it's not, we ignore it. Which makes life easy then when you get down to the answer choices, because when, let's look at the facts. Owner is competent, possessor enters, and then owner is adjudicated incompetent. We don't care. It's irrelevant. So we don't care when that disability was removed because it doesn't matter in the first place. Now, important also, D is the right answer. It doesn't give you a rule of law. Oftentimes, these days, again, they're making the questions harder because they don't give you the rule. But if you apply the rule, you know that D is the right fact set that gives you the right answer here. Possessor wins, or owner loses in this case, because the disability wasn't in existence when possessor entered in year 1. We've got a 7-year statute of limitations, and it is now year 8. The clock is done ticking, and owner loses. So be careful that you don't automatically go for a rule of law in an answer choice, because oftentimes it'll be a true statement of law, but it won't be the right answer because it doesn't match the question. Any questions on 4? All right, number 5. Okay, I think we're all in. Okay, pretty good. Now, notice a couple of things here. And yeah, please, as the mood hits you, we still have plenty of pizza, so please feel free to tuck in. It's an evidence question. Most of you answered it pretty quickly because it's short, and you know the answer or you don't. And the answer, of course, is B because it's habit. What makes habit here? Always, yeah. And you know, whatever commercial course you've had, or if you had ALS, you want to be careful with those absolute words because usually they're the wrong answer. But sometimes it does matter. Habit is one of those places where always matters. Or Civ Pro, which you're going to have now. Every pleading must contain a prayer for relief, right? So you shouldn't throw an absolute out automatically. Here, it's the right answer. The other thing I want to point out here, character, habit, habit, character. One of the most common wails It's the only way to describe it. I'll hear from students is, oh, I don't know what to do about character evidence, right? You haven't studied evidence yet. You probably haven't hit that wall, but you might remember that from your evidence class. Here's what you want to do with evidence. I'm going to suggest an approach. I didn't come up with it. I wish I had, because I think it's a really good approach to evidence, but it works in answering these questions. It's a three-step process. The first thing you want to do is identify what kind of evidence you have, which is usually pretty easy. Is it real evidence? Is it the murder weapon used to kill somebody? Is it demonstrative evidence? Is it testimonial evidence? Determine what kind of evidence it is, because that may affect its admissibility, its chain of custody, other issues. Usually that's an easy step, but make sure that you know what you're talking about. Now, second step is the key. You get the answer to the second step right, then you'll know whether the evidence is admissible or inadmissible. And notice, by the way, that what you're doing is you're not starting with the rule. You're leading yourself to the rule, because that's one of the common problems people have with evidence. There's so many rules, and how do I sort through them? Lead yourself to the rule. The second step is the key. What is the evidence being offered for? And you need to be very critical here. I'm going to beg you to assume it is not being offered for the truth of the matter asserted. Everybody goes right to hearsay, usually the wrong answer. So think of everything other than hearsay that the evidence might be offered for. Is it being offered to impeach? Is it being offered to show ownership or control? Is it being offered to show notice? Go through that whole list of all the different things that it could be offered for. And also ask, is this a civil or a criminal proceeding? Is it being offered by the plaintiff or the prosecution or the defendant or the defense? Is it being offered on direct or cross? Because as you go through that checklist, you're going to get down to a narrow rule. Instead of, again, jumping in and trying to sort through a bunch of rules, you lead yourself to the right rule. And don't think about character evidence as this big behemoth. Again, go through those steps. If it is character evidence, reputation, or character for truth, is it being offered to impeach? Is it being offered as an element of the cause of action, defamation? Or is it the defense in a criminal proceeding offering evidence of good character, peaceful traits, for example? So use that approach. Be very methodical in that second approach, because then the third step, which is the evidence admissible or inadmissible? Usually you'll already know what the answer is again. Okay, questions about number 5. And we'll think about that approach again when we get to Florida evidence a little bit later. We'll do a multiple choice set on that in a later session. Okay, number 6 we're doing. Okay, number 6. Okay, we are all in. Let's see how we did. Of course, this question deals with Civ Pro. Wow, you guys did very well on this question. It's new to...
Civ Pro was on something today.
Oh, you had Civ Pro today. Oh, you guys, well, good, you were paying attention. I should have, yeah, we'll see if I give you the same question next week, if you remember the rule. We don't know for sure how they're going to test Civ Pro. I actually sat down with Professor Nathanson, and I drafted this question and sat down with him to get his reaction to it, because I don't teach Civ Pro. Pretty much everything else we're doing today I've taught at one point or another, but Civ Pro is one of those things that I kind of stay away from. I never liked it in law school. But it's a good question because it makes you work through the rule, which you clearly did remember. So let's take a quick look for the benefit of anybody who didn't get it right. We're talking about venue. Remembering, of course, with diversity that we need how much diversity? What's the word? Complete diversity, which we do have in this question. If you don't have complete diversity, which means that no plaintiff and no defendant reside in the same state, then you don't have federal jurisdiction, at least not based on diversity. But we do have complete diversity here because everybody lives in a different state. So now the question is venue. And of course, A is correct because, fill in the blank? Okay, substantially all of the events occurred, the accident. So it is proper for venue. But B, of course, is wrong. Do we care where the plaintiff lives for venue purposes? No. We do care where the defendant lives, though. If all of the defendants reside where? In the same state, but they don't here. So we can't base venue on residence of the defendant. We're left then just with A. Obviously, you guys don't have any questions about this one. All right, number 7. That means when we get to the other Civ Pro one, you're going to all get it right too, right? Number 7. Okay, looks like we're good. Let's see. Okay, pretty good. Not everybody got it right, but most of us did. The call of the question, of course, is negligence again, and they do love to test negligence. What's wrong with A? A few people pick always, right? We're talking about the reasonable person in the shoes of the defendant. So it depends what a reasonable person would do. And the example I use usually, and some of you have probably heard it before, if I leave here and I've got a bottle of water and I go out to my car and I'm in a hurry, I put the bottle of water on the top of the car, we all do something like that, and throw my bag in the trunk, and I start to drive away. And I'm out there and you guys are standing around talking and somebody's going like this. Oh yeah. Should I stop and get the water bottle? Yeah, probably. because I can, and it might fall and hit somebody or damage the car, you know, I should probably stop. But if I get all the way out to the Palmetto with the bottle of water on the roof, and you're laughing, but apparently, according to my niece anyway, it actually happened to my brother-in-law once. He's driving on, I don't know, 95 or someplace with a coffee cup. And it happens. You see all sorts of strange things on the highway. If somebody's driving along beside me going like this, am I going to stop on the Palmetto? I'm not. I don't know about you, but I'm not stopping on the Palmetto. So the always is the key here, which is what makes A the wrong answer, going back to that issue of absolutes. Now, B, of course, is the right answer, but we have layers in this question that a lot of you probably didn't even think about. We actually have two duties in this question. First duty is to secure the suitcase. Duty was met, apparently. There's no evidence that driver didn't secure the suitcase properly. But now, once it comes loose, which wasn't foreseeable, so there's no breach. If there was a duty, no breach, no causation in respect to that first duty. We have a second duty now that arose when the suitcase hit the road. And I took a case from Prosser again, but kind of changed the facts because that case actually involved a cow that got hit. And you may remember it. A guy was driving on a road at night, came over, it was an unlit road, came over the top of the hill and ran into a black cow, killed the cow, and left the cow carcass sitting in the road. Oh, I know. It's a little too gory. But he didn't do anything. He just kept on driving. And so another guy came over the hill and hit the cow because he couldn't see it. Now, there was probably no breach of duty in respect to hitting the cow the first time. The road's dark, the guy couldn't see the cow. But a new duty arose when he left the carcass in the middle of the road.
What if that was me? How am I supposed to get that cow?
Yeah, exactly right. Well, and it's good.
Duty changes to give notice to the.
Okay, yeah, you put the flare out or you put something on the side of the road. Or today, what do we do today? You hit the cow, what do? You get on your cell phone. You get on your cell phone. So,
We don't have to worry about that this year.
once again, the moral of this particular case is there's a second duty, and you have to meet the second duty, which is the question here. And you might disagree with the outcome in that particular case, and honestly, it's an old case. Cow wandering in the road, no lights on the road, wouldn't happen today probably.
You just like make a call like to the cops or something and tell them like, hey, I hit a cow, it's in the road. Is that enough?
What would a reasonable person do under the circumstance?
You're gonna give me a ticket?
Okay.
Oh.
Yeah.
Do you call AAA or something?
What you might call AAA. I don't know. Were they going to haul the cow? I don't know. So, and by the way,
We'll get mattresses.
don't argue with the facts. You take the facts as they're given. I see a lot of people doing that. They want to try to change the facts. You can't change the facts in an essay. You can't change the facts in the multiple choice. So just take them as they are. Okay, any other questions about this question? Number 8. All right, let's see how we did on number, actually, very good. All things considered, because this is a tough question for a couple of reasons. Well, it's contracts. Nobody likes contracts, number one. I like contracts. Most people don't like contracts. It's, of course, Article 2 again. Don't assume, of course, that all of the MBE is going to be Article 2, but there's a reason why I wanted to put this particular question in here. Article 2, you know, if you think back to your contracts class, and how many of you, by the way, took sales? Anybody take sales? Maybe not. Yeah. So there are big pockets of Article 2 that you don't know, because you cover certain things in contracts, and the basic idea of a requirements contract you did cover in contracts, but not the level of detail that you have in this question. So understand that. Don't assume that when you get to contracts that you know everything there is to know about Article 2. And that's not the fault of anybody. It's just the limitations of a first-year contracts class. So, of course, we're talking about requirements contracts. But what this question shows you is it's a little bit off the beaten path. It's not talking about demands for more. It's taking less, number one. But you have actually a whole body of cases dealing with this particular point. And importantly, it goes to the comments, to the code section. This particular question deals with 2205. 2205? What is it? Well, it doesn't matter. I should know that section number. But the comments actually tell you how to answer this question. And the language in that section, which talks about increased talks about demands, unreasonable demands, is limited to increased demands. So no unreasonable demands means you can't ask for a lot more. The question is, what happens when you don't ask for anything? Now remember that if there are stated estimates, that kind of forms the bell curve, if you will, and you can't go too far either way. But if you ask for nothing at all, the question is, why did you ask for nothing at all? If you asked for nothing at all, because you're just trying to save money, then you've breached the contract. But if you ask for nothing at all because you've gone out of business, then you've acted in, what phrase would we want there? Because the demands, good faith. Demands always have to be made in good faith, as you have to do everything in a contract in good faith. But in particular, if you close your business and so you have no need for the item, you are still acting in good faith. So again, the question shows you some things to keep in mind. Number one, that you definitely haven't covered everything about Article 2 in your contracts class. Number two, look at the comments to Article 2 matter a lot, and then 3, case law does too. Yes, sir, Chris.
Is that the same for output contracts?
Yeah.
This nuance is just for...
Well, this particular, actually, it's a good question. It talks about demands, and it's talking about requirements contracts. And I haven't actually seen a case that deals with outputs on this particular point, although I think it probably, you could use it by analogy. It's a good question. Okay, questions about this question? And let me ask you also, we've been going for almost an hour and a half, and I would guess we have probably another half hour left. We can take a break if you like, or we can just power through. I would, for you guys, I think you'd probably rather power through. Yeah. When we get to Florida Con Law, you're going to want to take some breaks. Okay, so let's just go ahead and power through today. And let's do question number 9.
Is that a play at Judge Pepper?
Did you have Florida Con Law?
Yes.
Oh, yeah.
Okay, so then, okay.
Yes. It was fun.
It's not, Florida Con Law cannot be made any more exciting than he tried.
That guy's a ball of energy.
Which I'm sure he would admit. Anybody else on this one? Okay, we're good. All right. See how we did? Good. Which doesn't necessarily surprise me. This question is a fairly easy question again, dealing with standing. However, I do want to point out that they love to test threshold questions. You'd be surprised at how often they come up, which is why I have this question included here. And just a little thing to put aside to think about when you're studying Florida Con Law. And we'll talk about the essay subjects on Friday, but I think there's a pretty good chance you're going to get Florida Con Law this time because it didn't show up last time. There are lots of little threshold questions hidden in those Florida Con Law questions. And you pick up points that a lot of other people don't if you're attuned to those issues, mootness, ripeness, standing, which we have in this question. So just again, pay attention to threshold questions. Now, in this particular case, of course, the cause is not moot because live controversy. And what tells you, there's one little phrase there that tells you that it's a live controversy? Class action, thank you. Just reading comprehension. Of course, it's also the type of cause that capable of repetition yet evading review. But so remember that little phrase again, capable of repetition yet evading review. But class action, I made it real easy. Gave you the class action again to illustrate the reading comprehension part of the exam. Questions on number 9. All right, number 10. We're gonna probably About 20 minutes more. We're actually moving along pretty good. And how late are you here today?
5.
Till 5.
But I'll wait till you finish.
Okay.
everything.
We should be done by 5, Susie.
Okay, I'll come back then at
Okay.
5.
Anybody else? All right, let's see how we did. Pretty good. C is the right answer. Now, of course, we're talking about whether guests had a reasonable expectation of privacy. And remember, I told you, you got to know case law. When it comes to constitutional law and federal criminal procedure, you need to know the cases because the questions will be based on cases. And of course, we know, and the name of the case is escaping me, but the name doesn't matter. You have to be a what? Overnight guest to have that reasonable expectation of privacy. Yeah, thank you very much. Yeah, if the more cases you know in the area, you won't have to recognize them by case name on the exam, but the more cases that you know, the better you will do with these questions. Okay, any questions on this one? If not, number 11. Okay, anybody else out there? We good? All right, let's see how we did. Okay, it's one or the other of those. Actually, it's D. Now, I'm going to ask, and those of you from ALS, the first thing you should have done, of course, is go to the statute. And can you guys remember, what did I tell you about how you decide what kind of statute we have?
How many times it says it?
Thank you. Exactly right. How many times does this one say? Two. So it is a race notice statute. Good. First thing you do is identify the statute. Now, let me explain why you look for how many times it talks about recording. With a recording statute, leaving aside a pure race statute, which is whoever records first, which is too easy, they don't test it very much. Notice or race notice, you've got two claimants. And you've got the first one, you've got the second one. If the statute talks about one person recording, it's aimed at the first person who has to record to protect against the subsequent purchaser. If it talks about two persons recording, then it's requiring both the first person and the second person to record, which makes it race notice. Now, to analyze under a recording statute, notice or race notice, you have a series of steps. The first three are the same, whether it's notice or race notice. First, you have to decide who took subsequent in time, who's your later taker, chronologically. That's all you'll have to deal with for the purposes of the exam. So A took first, and then B took. B is your subsequent person. Then, did that person pay value? And the good news for the purposes of the exam, they don't go into some of the more difficult issues in terms of value. It's going to be all value or no value at all, gift. Of course, if it's a gift, then that person isn't protected by the statute. But assuming that value has been given, the third step is, was there notice, actual notice? Did somebody show him or her the deed? Record, notice from the recording in the right place, or inquiry notice, something about the land, cars parked in the driveway, clothes on the clothesline, stuff like that. And if your subsequent person paid value and had no notice, the subsequent person wins in a notice statute. If it's a race notice statute, that subsequent person has to record first. And that means have a complete recorded chain of title, by the way. Now, if your subsequent person is not protected under the recording statute, whether it's notice or race notice, what rule do we use? First in time, first in right. So your first person, who does not have to qualify under the statute, by the way, just be the first person, wins. And in this case, owner promptly records. Good news, right? And we have a race notice statute. Vendee doesn't record. Is Vendee going to win? No way, right? Because Vendee didn't record. I'm sorry, wait, I got to go back. Wait a minute. What did I give you? I gave you just a notice statute, didn't I? No, it's a race notice. I gave you a race notice, yeah. I got to look at my own question. So if it's a race notice, then Vendee can't win because Vendee didn't record at all, let alone first, which means first in time, first in right. Who's first in time? Purchaser. Now, a little note on recording. It is hard. A lot of people struggle with it. They love to test it on both parts of the exam. You'd be surprised at how much it shows up on the Florida portion. And we are a notice jurisdiction, by the way. I'll make a little note of that one. Notice. Pure notice, yeah. Spend a little time trying to work through it. It will be well worth your time. If you can get these questions right on the MBE, you're going to pick up points that a lot of other people are not going to pick up, because a lot of people are just going to say, can't get it, move on. And it does show up a lot on the essay portion of the exam. So being able to handle it when you come to the Florida part is a good idea. Okay, any other questions? Number 12 then. Okay, let's see how we did with number 12. A lot of you are still awake, some of you aren't. Those of you who got the wrong answer, what did you miss? Least accurate. We're looking for the wrong answer. This question is strategically placed toward the end of the packet. We got 14 questions, it's number 12, to see if you're still awake. And some of you puzzled and puzzled because 3 of them look good, right? You know, they're right, 3 of them are right. And it's an easy question if you circled, underlined, put an asterisk by least. We're looking for the wrong answer. And of course the topic is counterclaims, compulsive, permissive counterclaims, right? A is true. You must bring a counterclaim if it arises out of the same transaction, right? Okay, it's correct. It's the wrong answer. C says seller may bring a counterclaim if the claim arose out of a different contract. Permissive, right? Correct statement. D, seller may elect to sue later if it arose out of a different kind of the same thing. Correct. And then you get to B, which says that seller may elect to sue, but only if seller's claim arose out of the same contract. That's wrong. It's very wrong. And so if you went through each of them and said, correct, wrong, correct, correct, if you had missed the least accurate, you would then go back and look at that call of the question again, right? So don't forget to read carefully, especially when you're tired, which you are right now. Think about that exam. When you get to about 2 hours and 50 minutes into the exam, or maybe even 2 hours and a half, you're tired and you lose your focus. It's when you make stupid mistakes, like some people may have made on this question. Okay, we have just 2 more, so let's go ahead and, as Chris said, let's power through number 13. Okay, it's an evidence question. It's short. You know it or you don't. Let's see if we know it when it comes to, oh, that's so good. A is the right answer. This particular question is you know it or you don't. And it's one of the reasons I like to include it. Because there is a difference, of course, between the marital communications privilege and spousal immunity, both of which are recognized under the federal rules. We're going to see when we get to Florida that we do not have spousal immunity. Big difference, but we'll get to that later. So we need to distinguish between these privileges. They like to test the difference between the two, so beware of that. And of course, with marital communications, first of all, the communication has to be made when? While they're married and in confidence, yeah. If you're out to dinner with a group of people and your spouse and you say something like the spouses said to each other in this particular question, it's not in confidence, and so it's not protected. Now, who owns the marital communications privilege? Key here to this question.
The defendant. Or no, the wife.
The husband, whoever shares the.
Both spouses. For marital communications, both spouses own the privilege. For spousal immunity, who owns the privilege? The witness spouse, yeah. There's your difference. For marital communications, both spouses. So, could this, by the way, could this particular communication be protected by spousal immunity? It could be, but she's waiving it, right? Because for spousal immunity, the parties have to be married when? That's for marital communications. At the time of the testimony, yeah, exactly. But it's owned by the witness spouse, and in this case, the wife is choosing to waive the privilege. Husband can't object under spousal immunity. But marital communications, were they married when the, and the thing that we're talking about, by the way, that the husband said, it's a what?
Admission.
It's an admission, right? That layers in evidence, and you need to identify the fact that it's an admission, which of course can be used against him unless it's privileged. Now, it was made while they were married, and was it in confidence? Yeah, they're sitting alone, so it's in confidence. That means it's potentially protected. She can waive the privilege, but he can still raise the privilege, which then makes A the right answer. So you have to go through a lot of steps when it comes to these privileges, and again, they like to test them. Okay, last question. I think we're missing somebody, but it could be a dead clicker too. All right, close enough. All right, let's see how we did. And if there's anybody out there from ALS who got this one wrong, which is part of the reason why I included it, right? The right answer. Okay, it should, because it's the same question, and it's also the last question again, which is what I did to you guys in class, to kind of underscore the importance of taking something away from the process. If you keep missing the same question, then you're not learning from the process, right? Folks from ALS, you want to tell everybody else what the most important thing here is in this question? It's an attempt. Inchoate crime at common law, all inchoate crimes are specific intent crimes. Now, for those of you who didn't have ALS, really important to understand in the area of criminal law, they will test you primarily on the common law. Even though in your criminal law class, unless you had my criminal law class, you probably spent most of your time talking about model penal code because all the books do. The bar doesn't test MPC very much. It tests the common law. I'm not sure why, but they do. So there it is. So you need to go back, particularly if your professor didn't spend very much time on common law, and learn the common law rules. And again, attempt, all inchoate crimes, attempt, solicitation, conspiracy, they're specific intent crimes. The other thing, especially again, for those of you who had other criminal law professors, the bar exam really likes to test the theft crimes. And if you did MPC version, you just have kind of a unified theft crime and you don't worry about all those nuances. But the bar goes into the differences between larceny and embezzlement and false pretenses and larceny by trick and all of those picky theft crimes. So make sure if you didn't have those crimes in detail in your criminal law class that you review them. Okay, now, a couple of things as we leave. What did I do with them? Okay, I have analytical answers, which you can pick up on the way out. They'll also be posted if you don't pick them up. That's number one. Number two, I think we're missing a couple people here. And if you didn't sign, sign. Did I miss anybody in terms of your ticket?
You got it once you gave us this, right? You got the other ticket when you gave us this? You gave us the handout?
No, you take the ticket that's on the handout, you put your name on the back, and you,
Oh, okay.
okay? You know, going once, going twice.